Hello, everyone, and welcome. Welcome to Raising Money through the Jobs Act, Rule 506C. I am delighted you could join me. My name is Larry Pino. I am the founding partner of a law firm in Orlando, Florida, Pino Nicholson. And we do commercial law in general, but very specifically, we do a great deal of securities work in dealing with different types of exempt securities and certainly a number of different types of offerings for private enterprises. This particular webinar is focused around the Jobs Act, and even more particularly than that, focused on Rule 506C. So with that said, let me go ahead and just get started, and we can get into the meat of what will probably be about a 20-minute webinar on this particular subject. Let me talk a little bit. If you take a look at the agenda of what we're going to be discussing, we're going to talk about the Jobs Act as an overview, how the law actually works, what the opportunity is for you at this point, what the advantages of Rule 506C are, and then how to structure it, and then based on that, what your benefits are going to be. Let me talk first of all, though, a little bit about giving you the foundation for how the Jobs Act was actually created back in the recession when Congress was certainly dealing with the throes of what was a very stagnant economy, recognizing that startups, generally speaking, are the ones that can really energize. We're trying to figure out how startup companies could in fact raise capital in a context of securities laws which were substantially complicated and relatively difficult for startups to be able to raise the capital. What ultimately happened is they passed a law in 2012, and President Obama at that time signed it into law and suggested that there were some modifications to the Securities Act which were designed to be able to make it easier for businesses to raise capital. And so there were two particular components that really became extremely prevalent. One is what we're talking about today, which is a 506C, and there's another one that I'm going to deal with in a different webinar environment, which is called Reg A, or what's now known as Reg A+. So specifically with respects to 506C, the SEC had to pass muster on it and get some particular regulations in place, because the only thing Congress did is it just simply authorized it. But as to how it was going to occur, what the rules were, and so forth and so on, that was going to actually take some additional activity on the part of the SEC. Those rules became effective on October 23rd of 2013. While I won't be talking about it at this time, if you'll notice on this particular slide, when it came to Regulation A, or Reg Plus, if you will, those rules became effective as of June 19th of 2015, which literally is just relatively recent. So in any event, starting off with 506C, and I'm just going to show you that particular slide. Before we go down the bullet points, though, what I want to do is just give you very briefly the background as to what Regulation D is. We call it Reg D, and why it is relevant. Securities in general, and I'm sure that most people are familiar with stocks, for example, those are publicly traded stocks. So when you hear about Apple or Cisco or Disney or IBM and all of those are actual public registrations. It's a security which has to be publicly regulated, and therefore they go through the SEC, they get approved, and so forth, and then of course at some point they get listed on an exchange. That's what most people are familiar with. On the other hand, there are particular types of securities that are what are known as exempt from registration. That is, they don't actually get registered in the public exchange, they don't get registered with the SEC, and so forth. Those typically, there are some others, but those typically are and fall under the Reg D, Regulation D rules. And they tend to be very specifically exempt for different reasons. Many of us, when we're dealing with these types of exempt securities, and certainly lawyers who handle that for private enterprises, private business people, and investment groups and so forth, have used up to now a rule which was called 506B. And that's a particular type of regulation that allows individuals like many of you on the call to go out and raise money and to use an exempt security for that purpose. 506B required you to have a prior relationship with an individual. Why? Because you weren't allowed to go out and publicly solicit. You couldn't go out, you couldn't market, you had to have a relationship with the individual who was investing in your opportunity. While on the one side, that's a good thing, of course, because they knew you and you knew them, it's also somewhat of a bad thing because we're all limited by the number of friends and families and people that we have relationships with. So while it was certainly effective for the purpose of raising money in what's known as a country club environment of individuals that you had prior relationships with, it wasn't very scalable because you couldn't actually market that opportunity. So with 506B, you were not allowed to go out and solicit, you were not allowed to go out and market. And as a result of that, the use of a 506B in many instances, especially on a startup basis, was relatively restricted in terms of its applicability. So when the Jobs Act got passed and when it went to the SEC, the whole concept was to be able to use this particular 506C Reg D offering to allow individuals to go out and actually market to people that don't know anything about who they are, don't know anything about the opportunity until they actually see these particular marketing materials. So as we go down the line, let's just take a look at what Reg D 506C actually says. The first thing it says is that there's an unlimited amount of capital that you can raise in a 12-month period of time. So what do I mean by that? I mean literally unlimited. So if you're raising $5 million, you're raising $10 million, you're raising $50 million, you can use a Reg D 506C exempt offering. So you don't have to get it approved by the SEC. It's an exempt offering. You can use that to raise that amount of money. In addition, unlike what I just suggested in the prior exemption, 506B, this one, 506C, allows you to have public solicitation. Now, that public solicitation is any form of solicitation. So you can use newspaper ads, you can use direct mail, you can do tombstone ads, you can do seminars and introduce people to your particular business or investment opportunity. You can use any one of those types of things, but it can be complete public solicitation. What that means is you do not have to have any type of relationship with a person who is ultimately going to invest in this particular exempt offering. Now, notice what the other bullet says, though. It's public solicitation permitted, but it is limited to accredited investors. Now, what the rules in this country for securities provide is that an individual has to be either an accredited investor to invest in a exempt security or a suitable investor to be able to do that. 506B, for example, says accredited or suitable. However, with a 506C, what the SEC is saying, what obviously the law says is, I'll tell you what, we're going to let you solicit to the general public so that you can actually make this offering available to an investor who doesn't know you and is meeting you for the very first time based upon that solicitation or that advertisement. But that person is going to have to be accredited. In other words, they want to have a level of sophistication on the part of the investor which would suggest that person is going to have to be an accredited investor in order to be able to invest in this particular offering. Now, what is an accredited investor? There's a definition in a subsequent slide, but let me just simply tell you, it is somebody who makes more than $200,000 a year for the prior 2 years with an expectation of making that much money this year, or $1 million worth of assets, excluding the personal residence. Those are known as two types of ways to test for an accredited investor. One is by income, the other is by assets. If it's a joint investor, they can make not $200,000 a year individually, but they can jointly make $300,000 a year for husband and wife for the prior 2 years and an expectation of making that much money this year. So let me just simply recap for you very quickly. In order for you to be able to publicly solicit, and you are allowed to publicly solicit with 506C, you do have to be an accredited investor in order to invest. That is, that the investor who comes into your offering has to either make $200,000 a year for the prior 2 years on their tax returns, or have assets of $1 million excluding the residence. In addition to that, what you are going to have to do for those accredited investors is you do have to verify their accreditation. Now, you can do that a couple of different ways. They can either send you their tax returns, or they can just simply show you a snapshot of their $1 million. Obviously, you can imagine that in some cases, investors obviously don't want to give you that type of private information. So they can certainly provide that their CPA or their attorney or their financial planner can give you a letter that says that they have seen that information and that, yes, indeed, these people are, in fact, accredited investors. So as long as you have that type of verification, either directly or in the form of a accreditation verification letter by a third party, either one of those gives you the opportunity to be able to do that. Now, the one final thing that you'll notice on that Reg D, the last bullet point, is that it is also exempt from state blue sky. What that means is that once you have a 506C, not only are you exempt on a federal level, you don't have to file it with the SEC, but you also don't have to file it in your state. So in Florida, for example, there's no filing. In no state is there a filing. It is exempt from any type of state regulation, if you will, in terms of the actual filing itself. Some states do have, Florida does not, by the way, but some states do have a notice filing. That just simply means that you file a form with the state that says this thing exists, but they don't have to pass muster on it. They're not required to pass muster, and in fact, they're not allowed to pass muster in order for you to be able to go out and use that particular offering. Okay, so that's 506C. What's the big deal, and why is it so advantageous? And by the way, before I get to that, this is the actual definition of accredited investor that I indicated, and you can see where we talk about the $200,000, and we talk about the assets of $1 million excluding excluding your personal residence or the investor's personal residence. So what are the advantages of the 506C? First of all, unlimited capital. Secondly, you have public solicitation. So let's say that you've got an opportunity to invest in an office building or in a historic property or in an actual tech business or a portfolio of mortgages or any one of those different things. You can go out, publicly solicit to investors, letting them know what this opportunity is. You don't have to have a prior relationship with them. You can have a dedicated website that shows them the opportunity and shows pictures of your historic properties, for example, and so forth. You can actually include all of your documents on the website so somebody can have access to them. Remember, you just have to make sure, though, that they are identifying the fact that they are accredited in order for them to be able to see. You can even do event presentations and do seminars to show people what these happen to be. All of that is an opportunity available to you with the 506C. Let me talk a little bit about the structure, because obviously I can talk a long time about this stuff, but let me just talk a little bit about the structure so you have an idea of how it works. One thing that you would do is for your offering, the offering is an investment fund. You're going to be using that offering in some way. You can either structure it as a fund or you can structure it as a company, either way. And if you do that, the first thing that you would do is you would form, and I typically use an LLC structure, by the way. It's a limited liability company. I don't use corporations for this purpose. There are lots of advantages to a limited liability company over a corporation, particularly now, and certainly in the state of Florida. So I tend to use as a Florida practitioner primarily, although I do these all over the country in terms of private offerings. But I will almost always, in any state that I'm operating or I'm doing an offering for a client, I will inevitably do a limited liability company over a corporation. So what you're going to do is you're going to provide the filing itself for the fund or the company. You have an operating agreement for the fund. I will typically also have a separate company who is the fund manager. I like to separate those two functions. So have an operating agreement for that. On the business level, that's all you're really doing is you're putting together a website, some type of tech platform. What I mean by that is a tech platform allows individuals to have access to those particular documents. You then have your home office or a regular office, some stationery, and some business cards. With that, you then get into the Reg D documentation itself. What does that documentation look like? So, for example, you've got your private placement memorandum. That's the actual offering statement itself. That's what somebody is going to read that says, you're going to be doing historic properties. Here's how I'm going to get, here's how I, as an investor, will get paid. Here's the preference that I would have, both on an operating level and in the event and at such time as these properties are sold, and so forth and so on. It talks about my rate of return. It talks about how my profit potential is, so forth and so on. That's all in the private placement memorandum. The subscription agreement is the document that your investor actually signs. And it says, I am going to invest $50,000 in this fund, and I sign on the back of that subscription agreement. It's a little bit, it has more disclosures than just that, but that's the general sense of what the subscription agreement is designed to do. The qualification profile is telling you that that individual is an accredited investor, and part of that qualification profile is identifying questions that establish that. It might be income questions, it might be asset questions, but it's giving you a profile of that particular investor. And so with that, you have an opportunity to then see what it is you're going to need in order to be able to verify that that individual is in fact accredited. Remember, I talked about this accredited investor representation letter that you could get, for example, from the investor's lawyer, the investor's CPA, the investor's tax accountant, registered investment advisor, however. So that's what that's referring to, the accredited investor rep letter. Certificate of ownership, once you get that $50,000 subscription and you get the $50,000, then you're going to want to send them a certificate of what they've got. So it could be a membership interest. It could be some type of debt instrument. But the bottom line is you want to send them what it is that they've now invested in. And that's what I mean by certificate of ownership. And then you want transmittal letters. So you'll want a letter that tells them, here's your certificate of ownership, welcome aboard, glad you're investing with me. And you might have 3 or 4 different types of transmittal letters. I refer to the Memorandum of Instruction, which is really my letter to my clients that goes through the entire explanation of how to use this particular private offering, what you should do, what you should not do, from a compliance standpoint, what you are allowed to say, what you are not allowed to say, and so forth and so on. And that's what I mean by a Memorandum of Instruction. Securities management is just simply the ongoing management of this. You've now obtained $50,000 from an investor. How do you account for that? How do you set up their account? How do you provide for your quarterly distributions and things of that nature? So that all falls inside securities management. So real briefly, what are you doing? You're structuring your limited liability company. You're then also structuring the limited liability management company. You're putting together all of these documents and providing for the ongoing management of those. Now, what does that mean now from your standpoint? Where are the opportunities? And if you'll notice, I talked about focused opportunities because offerings, generally speaking, are focused for lots of good reasons, both legal as well as practical. Nobody invests in just empty black boxes. They tend to invest in a particular offering. So we have, for example, an offering on in assisted living, senior housing facility, or in a particular type of distressed property opportunity, storage facilities, as an example in real estate, or an extraordinary property that has historic tax credits available for it. and so forth and so on. So I just simply listed some of those types of opportunities which would be relevant in this particular case. The flexibility is that once this company is created, there's a direct opportunity to invest. You could also provide for an arbitrage, which just simply means that you can take your investment dollars and invest in other funds that are investing in those types of asset classes, and you could keep the spread yourself. And of course, you're entitled to management fees and tax benefits and all of those along those same lines. So with that, I know that it was a brief webinar and a brief introduction to Reg D 506C, but I wanted to just give you an opportunity to think about that and to see whether it is something that might be relevant to you. If it is, you now know that a 506C exists and you have some basic understanding. By all means, if you would like to give us a call or to schedule a personal consultation or just ask some questions, by all means, you can give us a call. My assistant is Kathy Simmons, and the telephone number 407-206-6516. And of course, the consultation is absolutely free. It is strictly to answer any questions that you might have. So I appreciate you being on this call, and do hope that if you have any questions, by all means, follow up with us. Okay, thanks so much. Bye.